Good afternoon and welcome to this webinar. The reason why it's styled Eastern Region is because all four of us have connections, both past and present, with East Anglia. And we know this afternoon that not only are there a goodly number of you watching, but also people from further afield. So a particular welcome to you all this afternoon. And so far as the material itself is concerned, you will be receiving copies of it tomorrow by way of a downlink. So within the next hour, Katherine, followed by David, and then John are going to share their thoughts on a number of issues. And then at the end, if time permits, we hope we'll have a question and answer session. So without further ado, Katherine, over to you.
Good afternoon, everybody. My job today is to provide the case law update, and I'm going to be taking you through 5 important recent planning cases. I've got about 20 minutes, so I've got under 5 minutes per case. So I will try to be as efficient as I can be, and really that means I'll just be focusing on the key principles. In very brief terms, we'll be looking at conditions which purport to impose public rights of way, the interpretation of Section 106 agreements, the interpretation of paragraph 11D of the NPPF, the meaning of openness in the context of Greenbelt policy, and finally, the meaning of a building in the context of a listed building. So if we move on to the first case, this is the DB Symmetry case, a recent decision of the Court of Appeal. And there were 2 issues there. The first was quite a specific issue concerning the lawfulness of conditions requiring the public to have a right of way over development land. And the second was more general, on interpretation of planning conditions, and the court provided some useful, concise guidance which summarises the key principles, so a good place to look if that's what you need. In terms of what was decided in respect of the first principle, the court upheld the orthodox position from the old case of Shoreham. So that means, as all of you will know, a condition will be unlawful insofar as it requires a developer to dedicate land owned by the developer as public highway without compensation. And the court clarified that it's not just those very specific terms, if you like, that are caught by this prohibition. There doesn't have to be any actual dedication as such. In more general terms, any requirement that the public is given a right of way over private land will be unlawful, where that right of way is given without compensation. And so useful clarity in respect of that, that position, even if it is confirming the orthodox position. Although I understand there may be an application to the Supreme Court pending, so something to keep an eye on. As for the second issue, the guidance given on the interpretation of planning conditions, the court said this. The first principle is that words are to be interpreted the way that a reasonable reader would approach them. And that's in the context of the planning permission as a whole. And of course, that includes the other conditions. With reference to the Trump case, the court clarified that there's no absolute bar on implying terms, implying words into conditions, but restraint needs to be exercised. You need to be really cautious before you start going in and trying to imply words in conditions. Your starting point should be no implication and just looking at the express words of the consent. The court went on to say that there's no special set of rules that apply to the interpretation of planning conditions as opposed to other legal documents. So general principles of construction can be used when looking at planning permissions. Permissions, and of course as part of that, permissions have to be interpreted in their context. which includes the applicable legal framework. And so that means, in practical terms, the reasonable reader that we use as our benchmark for interpreting a planning permission can be assumed, or must be assumed, to have some knowledge of planning law and practice. So, for example, the key umbrella statutes and key policies like the MPPF. And where there's a choice between two realistic interpretations, the court will prefer an interpretation which results in the permission being valid as opposed to invalid. So in other words, an interpretation that saves the permission. And so looking then at how the court applied the principles to the rather unusually worded and, dare I say, poorly worded condition in that case, the key bit said this: the proposed access roads shall be constructed in such a manner as to ensure that each unit is served by a fully functional highway, hard surfaces of which are constructed to at least base course level prior to occupation and bringing into use. And the court held, which was in accordance with what the developer was saying, that condition, what it was really doing was regulating the physical attributes of the road. So in other words, how the roads that were going to form part of the development had to be constructed. It did not require, as the local planning authority was trying to argue, that the roads had to be dedicated as public highway, which in any event would have made it unlawful applying the Shoreham principle. So that's a whistle-stop tour of the Symmetry, DB Symmetry case. Moving on to Norfolk Homes. I need to just outline the background briefly so that this makes sense. In summary terms, a local planning authority granted a permission in 2012 for 85 dwellings, subject to a Section 106 agreement in the usual way, and that agreement imposed a 40% affordable housing requirement. There was then a Section 73 application granted in 2015, which, as you all know, results in a new planning permission. And that new planning permission was not contingent on any further Section 106 obligation. The other key point is that the Section 106 agreement from 2012 referred expressly to the 2012 planning permission. It didn't refer to any other planning permission or provide words that potentially expanded the permission being referred to. So against that background, the issue was whether the Section 106 agreement that put in place in 2012 could be interpreted to apply, was it triggered, in circumstances where the developer had elected to implement the new 2015 permission as opposed to the original 2012 permission. And the judgment really, well, it provides some very valuable clarity and confirms the orthodox position. Mr. Justice Holgate confirmed that Section 106 agreements are contracts and they're to be interpreted in accordance with the usual rules of contractual obligation. And on the facts of this particular case, the wording of the Section 106 agreement was clear. So it meant what it said, and it therefore only applied to the original permission, the 2012 planning permission. The judge rejected the local authority's argument that the Supreme Court's decision in Lambeth, which you'll no doubt recall concerns the approach to the interpretation of conditions in a permission, it was rejected that Lambeth decision changed in any way the strict contractual approach to interpreting Section 106 agreements. And in particular, there was no scope for saying that the local authority had to be somehow protected from falling into what the local authority there referred to as a technical trap. Mr. Justice Holgate rejected any suggestion that those sorts of concerns should somehow affect the principles of interpretation when it comes to Section 106 agreements. And he also looked at implying terms into Section 106 agreements. And he confirmed, applying the usual tests that you'll be familiar with from contract, that there are strict thresholds that apply. And applying those principles here was not the case that the implication of terms was required to give efficacy to the agreement, or that the implication was so obvious that it went without saying. And so really the Section 106 agreement meant what it said. There was therefore no requirement to provide 45% affordable housing, because the planning permission being implemented wasn't connected to the Section 106 agreement according to the terms of that agreement. Now that was a really quick whiz through what is a really important case. So if you are interested and want to know more, I would commend to you an article on the local government lawyer by my colleague John Pugh-Smith, and also a podcast that he's done on this case. If you find yourself having to advise on the interpretation of Section 106 of a Section 106 agreement in this sort of scenario, go and check it out for more information. Whizzing on then to the third case, this is the Peel Investments case. And the issues here were the correct interpretation of the phrase out of date in paragraph 11D of the NPPF, which of course is the tilted balance. And then also the proper application of para 11D to policies in a development plan which are time expired, or where there are no policies in respect of the strategic matter of housing supply. So just a very quick reminder, you can see at the bottom of the slide there, the wording of paragraph 11D. And it's just a reminder really that this is one of the triggers for the tilted balance. It's where the policies which are most important for determining the application are out of date. So that's what we're looking at here. And where that applies, permission has to be granted unless the various exceptions apply. So moving on to look at what the Court of Appeal made of this wording out of date. The court clarified that policies will be out of date in accordance with paragraph 11D if they have been overtaken by things that have happened since the plan was adopted, either on the ground or through a change of policy, change in national policy, or for some other reason. And you can see that is incredibly broad. And indeed, the court went on to say, unsurprisingly, that that really is a question of planning judgment, whether in a particular factual scenario a policy is out of date is something for the decision maker, and it's not a question of legal interpretation for us lawyers. And the court also confirmed rather helpfully that the analysis from Norfolk Homes, which everyone will remember in relation to paragraph 14 of the old NPPF, so the paragraph that previously contained the tilted balanced, applies appropriately revised in relation to 11D. So if you need further assistance with this issue, go and have a look in Norfolk Homes. So that was the interpretation side of things. As for the application side of things, and looking at the policies in that particular case, the court clarified that out of date has a different meaning from time expired. And there's nothing in paragraph 11D to suggest in itself that a time expired policy is out of date. And they're two different issues. Of course, that's not to say a policy that's time expired can't also be out of date, but that's not necessarily the case. And indeed, the court recognised that there are many policies that will survive beyond the plan period, so once they are out of date. And then on this question of a plan without strategic housing policies, we now know for sure that it is not necessarily, not automatically out of date for paragraph 11D purposes. And again, it all is going to come down to the planning judgment of the decision maker on the facts of a particular case. The penultimate case I want to look at is the Supreme Court's decision of Samuel Smith. The main issue there was the meaning of openness in the context of Greenbelt policy. And at that time, it was the old MPPF that applied. So just to remind you of the bit I'm talking about, certain other forms of development are also not inappropriate in Greenbelt, provided they preserve the openness of the Greenbelt. So it's one of the exceptions to development being inappropriate in the Greenbelt. And this particular case concerned a quarry, so it was the mineral extraction exception which was relevant. And it was the application concerned, well, a 6-hectare extension to the operational face of a quarry in the Greenbelt. And in looking at the application, the authority had considered the landscape impacts, but there was no express consideration of visual impacts. And it was found that openness was preserved on the basis of that analysis. And so in a nutshell, the question for the Supreme Court was whether that approach was lawful. Could you conclude lawfully that openness had been preserved without giving express consideration of visual impacts? So the court said this, in respect of openness, it's a broad concept, and it links back to the underlying purpose of Greenbelt policy, which is to prevent urban sprawl by keeping land permanently open. So that means then, in light of that purpose, Greenbelt is not necessarily about visual qualities of land, although in some cases that might be an aspect of the planning judgment involved in ascertaining whether openness is preserved. The court went on to say that it was clear from the MPPF, from the Greenbelt policy framework, that some forms of development could in principle be appropriate and compatible with the concept of openness, and mineral extraction was indeed one of those examples. And although a large quarry was not visually attractive while it lasted, the point was that its impact was, theoretically at least, temporary and subject to restoration. So on that basis, there's nothing in theory to prevent a development having a detrimental visual impact, but still preserving openness for the purposes of Greenbelt policy. And then the lesser looked at aspect of the Samuel Smith case, but one that I wanted to touch on briefly because I think it's important, is the useful analysis of material considerations. I practice more general public law as well as planning law, and I'm always a bit surprised in planning how lazily the material consideration concept is used, often without very much underlying analysis of why exactly something is a material consideration. It's just assumed that practically everything is. So useful to go back to first principles, and they're set out very nicely and clearly. The court clarified, and this is not new law, but it's just a useful summary bringing together the previous authorities, that a matter will be a mandatory consideration. So in other words, it has to be taken into account, and a decision maker will err in law if they don't take it into account, in 2 scenarios. One, where that consideration is expressly or impliedly identified as such by the relevant statutory and or policy framework. So if, for example, a statute says that a decision maker has to consider something and they don't consider it, very clearly that's a failure to take into account a material consideration. And the other scenario is where the matter is so obviously material, that's the test, that the decision maker has to consider it. So effectively, you can see that's a rationality test. It's going to be a very high threshold. And the court held that in the Samuel Smith case, on those facts, visual impact didn't fall within either of those categories. It wasn't a material consideration. So, well, or it wasn't a mandatory material consideration. So although it was perfectly open to the council to take visual impact into account, it wasn't actually required to do so. There was nothing specific in the wording of the Act, including Section 70, and also the relevant policies, including Greenbelt policy, that required visual impact to be taken into account. And finally, well, I've got 2 minutes left, which is perfect. Finally and quickly, the case of Dill. The issues here were whether a statutory listed building listing is determinative of a relevant item being a building in the context of a listed building, and then also the criteria to be applied in determining whether an item which appears in its own right on the statutory list is in fact a building, quote unquote. And the context of this was 2 lead urns which rested on limestone piers, which had been Grade 2 listed in 1986, and they'd been removed and sold by their owner, who had been unaware of the listing. And then subsequent to that, listed building enforcement steps were taken. So that's the context. On the first issue then, the Supreme Court held that the list itself was not determinative of an item's status as a listed building. So that meant that on an appeal against the listed building enforcement notice, the issue of whether the item in question was in fact a building could be raised. And the Supreme Court thought that actually an appeal against a listed building notice was exactly the sort of place where that kind of issue should be raised, because an inspector is well placed, has the necessary expertise, but also will have the evidence required to make a judgment on that issue, which could well involve really difficult questions of factual judgment. So much better for an inspector to do it equipped in that way than the High Court on an application for judicial review. And there were parallels there with the way planning enforcement works. It didn't seem fair to limit the basis on which somebody can appeal a listed building enforcement notice when they could appeal much more broadly against a normal planning enforcement notice. And the court clarified that if an appellant succeeded with that sort of argument, so persuaded an inspector that an item was not in fact a building, so not a listed building, there was an obvious remedy, if you like, because the Secretary of State had the power to remove the item from the statutory list. And then on the second issue, how one goes about judging whether something is a building in the listed building context, the Supreme Court confirms that the test in Skerritts will apply. So it's a case of going through those criteria and making a judgment. But the court also expressed its displeasure with the lack of clarity in this area and called for guidance, particularly in relation to freestanding structures like these urns, where the position seemed to be particularly unclear. So I suspect, watch this space, and we will have some new guidance on this kind of issue soon. So I believe I've only gone 1 minute over my time slot, which I think is acceptable. I'm now going to pass over to my colleague David, who is going to deal with the property law update.
Katherine, thank you very much for that very informative update on planning issues. And first of all, I echo what John said at the outset. It is a bit of a disappointment not to be live with you in Cambridge and the east of England, where I have significant connections. Firstly, my alma mater, Peterhouse, on the left, and secondly, I'm now part-time. I'm taking a PhD at the University of Cambridge at Darwin College on the right. So there is something simply for me to remember you by. But the nice thing is we have a lot of case law to go through when it comes to real property, particularly insofar as it affects the development of land. First, we're looking at rights of entry under leases for inspections and works, where the Court of Appeal made a number of comments in the case of Rees against the Earl of Plymouth. I then want to go on a whistle-stop tour of the tort of nuisance and remedies, because there have been some very interesting comments being made from the Supreme Court and some other cases about remedies. So let's talk about rights of entry under leases for inspection and works. First of all, they're important because they allow a landlord to carry out inspections pursuant to repair obligations. Also, depending on how they are worded, it allows a landlord to carry out works of improvement. So it might be the case that you want to redevelop at least part of a structure that you have let out to a tenant, whether residential or commercial. But in terms of a development perspective, it's that middle bullet point, undertaking surveys pursuant to development of land, which has created a number of issues in a line of cases along the years, particularly in relation to discharge of planning conditions in order to carry out environmental surveys. And often they can be intrusive, or they require some element of installing surveying or monitoring equipment. And that was the case in the case of Rees against the Earl of Plymouth. And there we have an extract from Wales Online of very unhappy looking faces on those bales of hay, because the family itself had involved in protracted dispute and litigation with the Earl of Plymouth, because their land, which had been demised to them in the 1960s, was part, or anticipated to be part of the nearby Plistell development. That's a £2 billion suburb that's being built in the west of Cardiff. Now, one of the grounds of possession for an agricultural tenancy is development pursuant to planning permission. So they had been served with notices to quit. And this case forms one part of their ongoing dispute, and that's to do with the landlord's attempt to satisfy a planning condition to carry out environmental surveys. They wanted to go into the land and to install equipment that would monitor bats. That's in order to satisfy a planning consideration. So let's look at the leases. Two tenancy agreements, one from 1965, one from 1968. And the tenant initially refused access to the landlord when he wanted to carry out an ecological survey. And the purpose of the survey was bats. Previous surveys had focused on newts, and it required surveyors actually being present on site counting bats during the night, as well as by remote bat detectors, which would be left on the farm for 4 or 5 days at a time. And the tenant objected to those bat detectors being left on the farm, and he also said that the surveyors had left their marking pins in a field. Now, the 1965 lease had a number of reservations. It had a right of entry to carry timber, and it had a right of entry in Clause 7. And it was a right for the landlord and his consultants and others authorised by him, with horses, carriages, and other vehicles, enter on any part of the farm, land, and premises at all reasonable times for all reasonable purposes. 1968 tenancy agreement had something slightly different. The landlord may at any time and at all times during said tenancy enter upon said premises with agents, servants, and workmen and others for purpose of inspecting the same, or for making roads, sewers, or drains, or for any other purpose connected with his estate. So as you can see, that nothing very much said about monitoring bats. The question was, could you read that into the terms of the lease? And the landlord said yes. They issued a claim saying that they did have rights of entry and applied for an injunction to prevent the tenants from stopping them obstructing access to the land, and they got an interim injunction. At first instance, the trial judge held that indeed they could carry out some surveys, but not all of them. And the tenants appealed to the Court of Appeal. And it's a very important decision in terms of how we interpret derogation from grant and how an implied provision as to how a landlord should not derogate from grant and a tenant should have peaceful enjoyment interacts with rights of inspection. And it's also a very important case overall on the interpretation of lease covenants and tries to deal with some of the baggage that some previous decisions might suggest we have when we interpret leases. And Lord Justice Lewison is very clear about this. He refers back to the ICS and West Bromwich Building Society case, because essentially what the parties were arguing about was a line of case law from the 19th century about derogation from grant and about whether or not it should be applied strictly. But Lord Justice Lewison said there's no need to go into that whole line of cases. Instead, what you need to look at is the entire principle behind derogation from grant. You cannot take away with one hand what you've given with the other. And it's a question of interpretation, and it's a question of assisting in that interpretation. And also, the language of the clause could be read as having two sensible meanings. One interferes more with the tenant's enjoyment of the land, and the other less so. Then you should be looking at the lesser interference. And Lord Justice Lewison made the comment at paragraph 21 of his judgment. In some ways, it's a circular argument. Because what are you looking at first? Are you looking at the right, or are you looking at the grant, or are you looking at what is said to be a derogation from the grant? So he went back to some of the line of cases which said it's all a matter of interpretation. So Lord Lawburn, in the case from 1907, if A lets a plot to B, he may not act so as to frustrate the purpose for which, in the contemplation of both parties, the land was hired. So also if B takes a plot from A, he may not act so as to frustrate the purpose for which, in the contemplation of both parties, the adjoining plot remaining in A's hand was destined. But Lord Justice Lewison placed a lot of emphasis what Lord Justice Nichols had said in the earlier leading case of Johnston against Holland. First of all, in such a case as a present, the exercise involves identifying what obligations, if any, on the part of a grantor can be fairly regarded as necessarily implicit, having regard to the particular purpose of the transaction when considered in the light of the circumstances subsisting at the time the transaction was entered into. And he particularly emphasised this comment by Lord Justice Nichols, that the application of derogation from grant principle is not dependent on a highly technical conveyancing notion. Instead, is a broad common sense rationale of a principle which bears the title of derogation from grant. You can't take away with one hand what you're giving on the other. And so he was very wary about interpreting documents by reference to strict rules applicable to particular classes of documents, including leases, and instead said that a lease is a practical document and you should take a commercial and common sense approach. At paragraph 32, he made a very important comment. Although the statement of principle is preceded by discussion of many cases referring to derogation from grant, the actual decision is little more than the application of ordinary principles under which terms are implied into contracts. And of course, that's a sword that cuts both ways. That if we're looking at a contract which is not a lease, does that mean we can take arguments, dicta, about non-derogation from grants and put them in? In this case, we are taking arguments here is referring to the case of Wilden and Burroughs, and that was about the implied reservation of easements in a freehold conveyance, basically saying you can't take with one hand what you're giving with the other. You need to look and interpret the actual grant of the right. So I think it's a lot to take away from a very important judgment. But he then went to dive a bit deeper into cases about rights of entry, particularly ones which evolved around environmental surveys. and he looked at Heronsley Hill Limited against Quick Fit Properties in a case of Mrs. Justice Sharp from 2009. She made this comment: such significant inroads into the tenant's right to enjoy premises free from interference is not a result, it seems to me, the parties would have contemplated when executing the lease. If such had been the intention of the parties to a commercial lease, one would expect to find much clearer words or indication to that effect within it. So what the judge was saying there was not a case of saying we're going to take a whole baggage of rules about leases and apply rules of interpretation strictly against a party giving a grant. Instead, what the judge was saying is we take the normal principles of contractual interpretation in the ICS case and say, well, what do the parties actually mean when they entered into that instrument? And again, that was a point that was also made in a subsequent case, Mr. Justice Nugi in Symmetry Projects Limited against Al-Qanatar Centrepoint Limited. The landlord cannot say that as the tenant took the device subject to his repairing obligation, the tenant has to put up with the landlord's works, however unreasonably they are carried out. But equally, the tenant cannot say that having given the covenant quiet enjoyment, the landlord cannot carry out the work unless it is shown to cause the least possible interference with the tenant's business. Both positions are too extreme, but where the two provisions fit together is that the landlord can carry out work provided he acts reasonably in the exercise of his right. And that brought Lord Justice Lewison onto a very important case from a few years ago. And that was the case of Timothy Taylor, about which much ink has been spilt and rewards a detailed reading, because that was a case about non-derogation from grant when the landlord was exercising his right to put up scaffolding. And the tenant in that case owned an art gallery. And that case, the decision of Mr. Alan Steinfield, QC, was all about balancing those rights. It wasn't about the landlord being obliged to take all possible steps to minimize disturbance. It wasn't about the tenant having an untrammeled right to have quiet enjoyment. It was all about a balance of those rights. So the nub of the case about contractual interpretation in the Earl of Plymouth case comes in paragraph 66, I think, and it's this. The derogation principle militates an interpretation which would result in a substantial or serious interference with a tenant's use and enjoyment of the leased property or frustrate the purpose of the letting. It does not require the court to give a right of entry to the narrowest possible interpretation. So what is it? It's an ICS-style exercise. Context. Part of the purpose of the contract is to confirm a tenant a right to exclusive possession of subject matter of letting on the terms of the lease or tenancy for the contractual term. So we have to balance those together. Lord Justice Lewison then endorsed a number of principles that the judge at first instance had set out. Not all of them, but a lot of them. So these were ones that Lord Justice Lewison actually endorsed. And so essentially, you would construe an exception so as to preserve its validity. The court will construe it as restrictively as is required to avoid a derogation from grant. But beyond that, there's no further rule, but a reservation is to be construed restrictively against a landlord. The court will expect substantial qualifications of a right to exclusive possession and quiet enjoyment will appear clearly from the lease. That's just a matter of common sense. And broad and unqualified words and reservations may be cut down when read in their immediate or wider textual context. And there's also no contra proferentum rule either. That simply isn't something that's going to be very useful. So it's not going to be entry for entry's sake. It's going to be an entry for a particular purpose. You can't look at the right in the abstract, and it must be something that works sensibly. And you have to balance the level of intrusion of works against the reasonableness of the purpose. And it was held the installation of this monitoring equipment on trees for a few days at a time was within the scope of a right to enter and inspect. Now, very briefly, I've taken another case about a residential letting that was decided before the Earl of Plymouth case. This is an important case because it is all to do with improvement to carry out cladding work and improvement to a structure. It goes beyond works of repair. And here the High Court, was a case about Ploughman Tower, a residential tower block in Headington in Oxford, This was a case where it was read against the background of a right to buy scheme, where leases granted under a right to buy scheme have to comply with certain statutory requirements. So it's already been held that this is not going to be works of repair. So there's a question mark. If it's certainly going to be works of improvement. The issue is, can Oxford actually go in to carry out the works? And his, Dr. Piechnik's claim was an action for damages, effectively for trespass. So jumping into it, this is the decision, this is the point they had to consider. And it was decided as a preliminary issue. And the answer that the judge gave on preliminary issue was effectively, it depends. And Justice Tipple was not terribly impressed with the idea of hiving off the sort of it depends style question to preliminary issue. It doesn't really seem to amount to preliminary issue at all. So as I suggested, you need to read it in light of the Housing Act 1985, and I've put those provisions up in the slide. Now, some of them only apply to light and air. As for other ones, yes, the landlord did have an repair obligation, but of course that got the landlord nowhere. This is going to be something outside repair. The question was whether they were acts of emergency, effectively to stop personal injury. And here the recorder said, yes, because it was this very limited exception, it was impressed upon the lease. And there the judge in appeal disagreed. You wasn't a case where you could read that into the lease, simply wasn't a case where that was going to be applied by virtue of the Housing Act. So there's no extended right. And this is something that I think is going to be quite important for a lot of landlords. And I've put up on their slide some important works by Professor Bright from the University of Oxford about this. Nuisance and remedies. We're quite familiar with the case of the Tate Gallery. I just wanted to highlight this as one of the most important cases of nuisance that we've had coming out this year, another case from the Court of Appeal. And here we have the question of whether overlooking from the Tate Modern into the flats was actionable by way of private nuisance, and is held no, mere overlooking is not capable of giving rise to a cause of action. And cited the case from the Court of Appeal last year, Williams Network Rail, where they discussed what private nuisance is. And again, it's been confirmed that this is a property tort. What we think of our examples of nuisance are merely examples. You shouldn't try and close them down into strict categories. In particular, damage is an elastic notion, but none of this availed the owners of the flat. Now, I referred here to a contrast with a very recent decision of the Supreme Court in Alexander Devine against Housing Solutions Limited about building in breach of a restrictive covenant. Because the point is this, a private law of nuisance doesn't give you any further rights in terms of overlooking, but if you have a benefit of restrictive covenant, that might very well be something you need to apply to discharge if you want to carry out works of development. So here there's a clear line, I think, emerging between planning and private law rights and what the courts will and will not do to extend property torts to protect what might be said to be rights which have not been granted between the parties. So restrictive covenants, I think, have an increasing importance when read alongside Alexander Devine and the Tate Gallery case. And I've written a couple of articles about both of those decisions. So a kaleidoscope of remedies cases. This was a case in the Supreme Court about patents, but the nice thing is there's a nice little comment about injunctions and mandatory injunctions, as opposed to damages in lieu of an injunction, because we had that decision from the Supreme Court in 2018 in Morris Garner, where that was considered, but we're still waiting, really, I think, for more guidance from the Court of Appeal. Lawrence and Fen Tigers, of course, damages were awarded for noise nuisance as opposed to an injunction. But again, the Supreme Court emphasised in Unwired Planet that this is a discretionary exercise. Here, they decided not to exercise discretion to award damages in lieu of an injunction. Certain facts of the case, of course, but essentially it would stop the party of being able to enforce against other infringements. Once you know damages are going to be on the table, have to be on the table, it's then very difficult then to go and enforce in other places. Finally, a case about unlawful eviction, Ruby Triangle Properties Limited, is interesting because it is an example of an award of exemplary damages. So it's because it's a company, they can't get aggravated damages, but even so, Master Teverson awarded the damages on an exemplary basis. First of all, my apologies for slides that have been bouncing around on PowerPoint. I'm looking at the questions. My apologies for that. It seems something to do with my video link. But in this case, the court did have power to award exemplary damages. So that's a quick whistle-stop tour through these property law cases. I think it restates the importance of private law rights in determining what can and cannot be developed. And I'd now like to hand over to John to talk about the next instalment, and starting with Rectory Homes and its implications.
Thanks, David. Hopefully everyone can hear me and that transition works smoothly. There's a prize for anyone who can recognise any of those three images. I won't give them away yet, but they're relevant, hopefully, to a couple of the points that I want to pick up at the end. Next slide, please, David. So I've picked up this case simply because it focuses upon something that had become something of a long-standing question about extra care housing in particular, and how it should be categorised in use terms. And typically in these sorts of appeals or these sorts of applications, the question relates to C2 versus C3 use issues. But here it was slightly different in that there was a proposed housing with care development, which was in use class C2, and whether or not that development was to be categorised as dwellings for the purposes of the local plan. And the essence of the claimant's case was set out at paragraph 26 of the judgment. Next slide, please, David. And the first point, or the first reason that this case is worth having a look at it in a little bit more detail, is because it helpfully set out a number of principles of interpretation. I've pulled out 10, although there's probably slightly more, but the 10 key ones that I've identified from the judgment are set out in paragraphs 43 to 45. I won't labour through each one of them individually, but some of them that are worth kind of putting an asterisk by and reminding ourselves about. Number one on this slide, harking back to Tesco and Dundee, the fact that policies are to be interpreted objectively in accordance with the language used, read in its proper context, and they're not to be interpreted as if they're statutory or contractual provisions. But there's also a reference at 3 to 5 about the practical implications, or the practical nature of the way that policies should be interpreted, and that they should be intended to guide or shape practical decision making rather than necessarily pored over laboriously by people like myself. Next slide, please. And in terms of this particular case and some of the issues that it raised and where the dispute lay, it's important to recognise the 6th and 7th points that I've put up here. And the 7th in particular, the fact that we can often get bogged down in supporting text and explanatory text as trying to work out precisely what a policy says and what it might mean. But there's a reminder here, and a reference back to the Church campaign case, that the supporting text isn't actually part of the policy. So although it might assist us and it provides us with an aid to interpretation, it certainly can't override it. And in terms of extrinsic material, there's a reminder again there that the public is generally ought to be entitled to rely on a public document as it stands. without having to investigate its provenance and evolution. And this is about all sorts of background documents that were pored over in this case, with the judge in particular sending a warning about the unnecessary forensic archaeology that was taking place. And again, a reminder that it's only really in cases of particular difficulty where extrinsic material may be examined. Next slide. So what was the policy in the case itself? Well, it was policy CSH3, and it said, as is set out on the slide, 40% affordable housing will be sought on all sites where there's a net gain of 3 or more dwellings, subject to the viability of provision on each site. And that policy operated by setting a threshold for its application, which was simply expressed as a net gain of 3 or more dwellings, and requiring 40% of the accommodation proposed to be affordable. The context of that policy was in a local plan where the terms dwelling, house, unit, and home were used frequently, but also interchangeably. And they weren't used in a technical or restrictive manner. And so, for example, that house didn't necessarily exclude a dwelling in the form of a flat. Next slide. And so the issue, or one of the issues, then became, well, what does dwelling mean? How can we apply or interpret dwelling in this context? And it was held that it was well established that the terms dwelling or dwelling house refer to a unit of residential accommodation, which provides the facilities needed for day-to-day private domestic existence. And that in particular, it wasn't a term of art confined to a C3 use class. And so properties having the physical characteristics of a dwelling may be used in a dwelling as a dwelling in more than one way. And so what was the outcome in this particular case? Well, it was held that where the units in an extra care scheme physically amount to dwellings, it really doesn't matter what alternative language a developer chooses to describe them, because they still remain dwellings. And in summary, there's no reason why a C2 development or scheme may not provide residential accommodation in the form of dwellings. That possibility is not precluded by the operation of the C3 use class and its interaction with the C2 use class. And thus the language of the order doesn't support the claimant's argument, or didn't support the claimant's argument, that the extra care accommodation proposed couldn't represent dwellings and therefore couldn't trigger the application of the policy. And so what does all this mean in context? Why is this case important? And we can turn on to the next slide, please, David. What does it all mean, and why is it important? Well, as I said, there's important guidance and a handy reminder about how to approach the interpretation of policy. Look at what they say, look at what they ought to mean in their proper context and when read in their proper context, and look to apply them practically with an eye to assisting decision making as opposed to necessarily forming the basis of legal argument. And then, but what does it all mean from a practical perspective? And I think that there are a couple of kind of headline points, really. The first is that in the reasonable amount of coverage that the case has seen, I think it's fair to say that the initial reaction from local planning authorities was to look at it as an opportunity to seek additional affordable housing in circumstances where they might not have sought affordable housing previously, but where their policy wording may permit of that sort of interpretation, such as in this case, we had the use of dwellings as that could be C2, C3, or even student accommodation. So authorities, I think, have tended to see the case as an opportunity, but I think that there's a number of reasons why there has to be a kind of note of caution sounded in that regard. The first is that I think that inevitably, and you can see that from the policy wording in this particular case, inevitably, if we look, or if authorities look to secure more affordable housing in this way across different types of specialist provision, then the argument is more often than not going to then focus upon viability. And that's a little bit of a careful what you wish for situation, not only because viability evidence is frequently contentious and can often throw up satellite litigation or satellite issues or appeals and expert input that's required, but it may not, or it may also mean that an authority doesn't necessarily secure the benefits that they might have thought that they would by originally seeking the affordable housing. There's also an issue, I think, with a kind of democratic deficit, in that if this case is used as a means for seeking affordable housing where it may not have been sought previously, then there might be arguments that could reasonably be raised about the consistency of their approach. And I think that there's also an argument that if such a change in approach is going to occur without necessarily a change in policy wording, then there's probably an argument that consultation ought to occur. And so it's about trying then to think, well, how can that occur? What sorts of processes do we need to have in place? Do we need to, for example, look at introducing a supplementary planning document covering the fact that, for example, student accommodation is going to be used or required to provide affordable housing, not least because SPDs allow for, in terms of their adoption, allow for a process of consultation. And so once that SPD is adopted, it might provide a more policy-oriented or focused basis for a change in approach. What are the implications, or what are some of the potential or possible unintended consequences with regards to specialist provision? Well, I've touched on a couple, the focus upon viability evidence, but there's also an issue with regards to extra care schemes in particular, and that's about the build cost and the fact that much of the work requires fairly significant upfront build costs. The types of sites that these schemes tend to be delivered upon are not sites where build costs are low, and they're not sites where they aren't required to be front loaded. And that ties into, again, the issue of viability, but it also ties into this overarching question, I think, about specialist provision in circumstances where we've got a rapidly aging population, and this type of provision is filling a gap that the public sector might otherwise have filled in previous years. And the fact that there's a wider public interest to be considered beyond the delivery or the perceived benefits of the delivery of affordable housing, because that might actually, you might gain some affordable housing units, but that might be offset by a reduction in the numbers of specialist provider schemes that come forward, or a reduction in the numbers of units that those schemes are capable of being delivered or capable of delivering viably. So moving beyond that, what are the issues that are outstanding from this case? Well, John's touched upon this in one of his articles for our newsletter, but I think that it's clear that there are some outstanding issues about C2 and C3 use classification generally, and that I think will have to be grappled with at some stage, possibly after we've all got our heads around the new Class E. But there's clearly a need for clearer guidance, both locally and nationally, in order that these sorts of schemes, these C2, C3 schemes, can be dealt with or assessed with certainty and consistency. And so I think that again ties into the idea that alongside possible additional guidance through the MPPG or MPPF, if and when it's rewritten, or a written ministerial statement possibly, but I think certainly there's a need for the local plan process to take this issue up and run with it. If there are plans that are going through the examination process or being written as we speak, then they need to grapple with this issue. And I think they need to do so head on and really determine at a local level how they're going to prioritise delivery of housing units. Do they need specialist provision in the form of C2 or C3 units more than they need affordable housing, for example? And likewise, if the judgment's read across to student accommodation, where's the balance to be struck there? Do they need more student schemes, or is it more palatable to seek a greater contribution of affordable housing from those schemes? And would that perhaps allow them to offset some of the local opposition to those student schemes? But either way, I think the lesson is that if you're working for or advising specialist providers, whether that's C2, C3 type specialist provision, or whether it's student accommodation, sui generis provision, I think that the answer lies, if you're advising those clients, that they need to engage with the process much more than perhaps they have done previously, because there is a real risk that in certain areas of the country, they will be being asked to provide affordable housing where perhaps their business model hasn't previously made allowance for that, or perhaps their the viability of their particular proposals hasn't necessarily allowed for that. So in order to shape their bottom line, or to allow for their bottom line to be palatable, they need to engage early, and they need to commit to the local plan process to ensure that there's no nasty surprises further down the line. So John, I think that just about wraps up what I wanted to cover on Rectory Homes.
Well, thank you very much, Jonathan. Well, we're just up to the hour now. I know you've got busy afternoons, a lot of emails backing up in your inboxes. So I'm going to draw a close here, but if I could just ask David to pass on to the last slide to tell you a little bit about our festival coming up. This is a new innovation. We normally have an annual planning conference, but we're going to spread it this time over 3 mornings on the 7th, 8th and 9th of December, covering planning, environment and property. But also we're going to do it in a fun way, which not only starts to celebrate, as it were, post-lockdown and a tiered up pre-Christmas, but also will allow hopefully a little thought to be given to those who really have suffered this year, particularly in mind as well as in body. And there's going to be not only sponsorship, but also charity giving to mind, the particular charity that we are supporting this year at 39 Essex Chambers. So on that note, I think it just leaves me to say thank you so much for attending this afternoon. As I indicated at the outset, the full presentations and just the slides themselves are both going to be available for download tomorrow. And we look forward to you joining us again when you can manage. Stay well, keep safe, and look forward to next Wednesday in whatever tiered form you will then be living in. Good afternoon and goodbye.